in the county jail all that time till the guy tried to use me as an scapegoat, and I protected myself. Can y'all hear me?
Yep. Can you hear us?
Yep, I can.
Okay. All right. Today's the date and time set for your motion, Mr. Whitsett, to withdraw your no contest plea. I've had a chance to review your motion or submitted by your attorney, review the response. So I'm familiar with everything. I'm going to offer you the opportunity to place anything on the record you'd like, but you don't need to repeat yourself because I've read it.
Okay. Thank you. Well, I think the gist of it is that this court needs to determine if the plea was voluntary, whether it was due to conditions of the jail, or whether it was a voluntary plea without any coercion. Now, there was no one from the prosecutor's office or the judge or his attorneys that coerced the plea. It was the condition of confinement. And I know the court, I think in this trial, took pains to go through and make sure that Mr. Whitsett fully understood his rights. However, I guess you can't ask every question that would lead to an involuntary plea. So the specific question, and I'm not faulting the court, but if the court asks, are the conditions within the Washtenaw County Jail leading you to want to get out of there and rush a plea so you can move on to the MDOC? I mean, that would have been the question, but of course, you know, you can't ask that on every case because you don't know if that's an issue. But I think the shackling was documented by one of his two attorneys, Ms. Hamoud, in her letter that I attached. So he was confined and vulnerable in the Wayne County or Washtenaw County Jail based on the conditions. And even when he's showering, he had to have the shackles 24/7, really, or anytime he was outside of his cell. I know that they did that for possibly because of an incident that happened with him, but he did allege that he was by Captain Clifton, who was one of the top people at the jail. And if that's the case, then if someone at that high level can attack him, then anyone can, and he didn't feel safe. So with that, I will request that the court, before making a ruling, will schedule an evidentiary hearing so we put all this on the record. Court can make a fully informed decision on whether the conditions of confinement led to Mr. Whitsett taking a plea when he was actually innocent and didn't wish to plead no contest like he did.
Okay. Counsel?
Thank you, Your Honor. So not to repeat, we do rely on the arguments in our brief, but just to highlight a few points in respect to co-counsel's statements. The standard of review here, Your Honor, is under MCR 6.310C, whether there was an error in the plea proceeding. And it's our position that the defendant has failed to establish any defect in the plea taking process. Without that, Your Honor, there would be no reason to allow withdrawal of the no contest plea or have an evidentiary hearing. In the plea taking under MCR 6.302, this court very diligently applied every single step of the requirements within that plea taking process. He was represented by not one attorney at that hearing, but two. Both of them agreed that the rule had been complied with and there are no promises, threats, or any other inducements. The only evidence that the defendant presents to this court is his own affidavit and a letter from Ms. Hamoud. Regarding the letter first, the conditions, his discomfort, if you will, with the restraints in the jail, case law is very specific. That's not going to be enough. With regard to the affidavit, his sworn affidavit is in direct conflict with his sworn in-court statements. And that also, case law is very specific, is not going to be enough to allow withdrawal of the plea. Regarding the veracity of the affidavit, we already know his comments regarding the May 5th incident, which is why he was required to wear those restraints, is untrue. We know that the record establishes in the May 5th incident in case 23-481 FH, that was part of a global plea agreement with this case. And in that case, he entered a no contest plea to aggravated assault and dismissal of a felonious assault and unlawful possession of a weapon in jail. And that police report, which was accepted as the factual basis, as Your Honor would recall, was for him attacking another inmate with a self-made shank in the back of the neck. So in that regard, the case law is very specific that when it's his in-court testimony at the plea stating that there were no promises, there were no threats, there were no other inducements, having an evidentiary hearing would only subject him to perjury to directly contradict that to those statements. With regard to the June 14th incident, we have presented an offer of proof in what the testimony would show, and that also would not bear to be true. Even if there was any sort of mistreatment in the jail, which we are not admitting that there was, the case law is very specific that the defendant has to prove that that mistreatment was aimed towards forcing him to plead guilty. And there's also no evidence of that. There's also no evidence that he ever presented any of this information to the court since the May 5th incident, despite the multiple hearings and even at the plea and even at the sentencing. So for all those reasons and the reasons articulated in our brief, Your Honor, we'd ask that it be denied in its entirety.
First of all, the affidavit does not conflict with the sworn statements in court because there were similar questions asked, but not a specific question about what was going on at the jail. I also was just handed a note by someone in the courtroom by the name of Sheldon Arnold. And he says he was in, I think it's I block. What? F block?
Counsel, like
Mr. Arnold says
and new information that someone's in the courtroom. So,
well, I mean, he was in the jail. He was an eyewitness, so it is an offer of proof. If we did grant an evidentiary hearing, I would have him as a witness. He said he saw Clifton assault Mr. Whitsett. So, I mean, that does lead to some additional evidence that he was legitimately fearing for his safety when you have a captain at the jail. You're supposed to be looking at the inmates and their well-being, assaulting him. So I think that leads to the credibility of the affidavit and calls for an evidentiary hearing.
well, you're correct that I don't ask every question at the time of an entry of the plea. Like I asked the same three big ones. Is anyone threatened you? Is anyone you? Has anyone promised you anything? And are you doing this of your own free will? And I know that I asked Mr. Whitsett those questions because I've looked at the video myself, but you know, I do them at every plea, and I wouldn't proceed if he didn't answer in that moment, you know, no threats, no promises, and I'm doing this of my own free will, or I'm not being coerced. So I took him at his word, and I took his plea. So now, you know, the matter is before the court because the defendant's seeking to withdraw a no contest after sentencing. The allegation is the endured coercion due to the conditions of his confinement at the Washtenaw County Jail. And that because of the conditions, he was unable to tender a plea that was understanding, voluntary and accurate. You know, I looked at Mr. Whitsett's affidavit. I've looked again back at the video, and you know, I don't find from what I observed at the hearing, what I observed at all the court proceedings, that the affidavit, I would say, is not entirely credible to me. And so at least some of the allegations or the statements, the sworn statements in the affidavit, don't line up with what I observed. So, you know, maybe things went on, you know, though there was an opportunity for Mr. Whitsett to say all of that before he entered his plea too, and we would have taken action at that time. I did re-review the hearing where Mr. Witset was tendered. He was represented by two attorneys. One of those attorneys was appointed on the assaultive case originating at the jail. Allegedly, the defendant made a shank and attacked another inmate, which created that second case. And then there were also other rules, I believe, that were disobeyed. And I believe those are the reasons it's placed on level 1 security. I can't make a finding now that there's a basis to withdraw his plea. The plea was knowingly, understanding, accurately, and voluntarily made. It comports with MCR 6.310C. I make a finding today that there was a defect in the plea, so I am finding that there was no defect in the plea taking process that warrants the withdrawal of the no contest plea in this matter. So I'm going to deny the motion today. I don't know if there's an appeal in that for you, sir, and if my bosses in Lansing tell me to reconsider it, I will. But at this point, I'm gonna deny the motion.
Can I say something? Can I say something, Your Honor?
Okay. Mr. Witset, no, there's not an opportunity for you to offer anything at this point.
Right, but you said there was no evidence in this on video. It's on video, and I told my psychologist what was going on. I didn't feel comfortable stating nothing about officer assaulting me because I was feared that I would have been assaulted again. That's why I waited till I came to prison. I would have never pled no contest to a crime I never committed. I admit to assaulting a guy.
Oh, you're on the record, right, Mr. Witset?
You know
you're on the record right now, and anything you say is being recorded. All that you're saying right now is going to be used at some point in the future, right?
Yes, I don't mind it. I never did nothing. I protected myself. And what made me plead out, I kept sitting there and getting adjourned. I was in the county almost 3 years, 4 years. And the incident happened. It was inhumane for me to go to a shower and handcuff and shackle. I'm in prison right now. And if I did something bad, you still get the shower, but you don't have handcuffs on you all the time. And it's violence in here. It's not like Washington County Jail. That was the only reason why I played that. My mental health was at risk. I was at risk. It's on video. We don't have to go off my statement. My word ain't nothing. The video shows that. The video shows it. Ask them for the video. And then let's take it. Let's postpone this and look at that video. If you see that video isn't enough to stand, I'll fall back from this, Your Honor. I never did anything in this the first case that happened. I was in the county jail all that time till the guy tried to use me as an scapegoat, and I protected myself. Look at the video. You see how many times he walked around me? We talking about a guy that's 6'5", 300 and some odd pounds. Your Honor, I'm 5'5", maybe 180 pounds soaking wet. He kept making threats, so I protected myself, Your Honor. If I'm wrong for that, hey, you make some good choices. I'm just saying, review the factual evidence, not my word, not nobody's word. The evidence off the camera. The body-worn camera by Sergeant Burleson on Justice. It's on that video camera. If I'm lying, we never have to go through this again. I'm not asking to make a decision right now. Postpone it until you see that video. If I'm wrong, hey, Mr. Witset, you lied.
So if the Court of Appeals tells me to do that, I assure you I will do it.
But you're going to deny me, though.
Okay. Yep. Thank you.
Thank you,
Your
Judge.
Honor.
Numbers 44 and 45, People versus Joe Thompson, 24-262 FH 22.1.
Yeah. Good afternoon, Your Honor. Jay Kilwell. Your Honor, I'm on Joseph Thompson's case, 24-262.
Good afternoon, Your Honor. Alexander, on behalf of the people, seeking permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of the prosecuting attorney, Jonathan Evans.
Joseph, would you state your name for the record?
Joseph Thompson. How are you doing?
right.
Judge Portia Feaster on behalf of Mr. Thompson for information violation of the 2211 FHS.
All right, so agenda, the world has all reasserted its correctness and rightness that you are here practicing under Emmons, so I'm happy to grant that motion. Mr. Kilowald, got to tell you, in your case, we don't have fingerprints, just letting you know that, because it's pretrial, and then in the VOP, we're just proceeding with that. So,
Judge, I would ask you to hold off on the VOP. Obviously, that's my case and that's your decision, but as far as the pretrial, I'd like to adjourn this out maybe 2 to 3 weeks. I just had a chance to speak with my client regarding the preliminary exam we held. And I think there's some substantial points I'd like to file a motion to quash. I'd also like to discuss with Mr. Emmons, a situation I believe is happening with the victim. But all that being said, I'm wondering if we could adjourn this 3 weeks.
sir, I assume you would make the same request on your case?
Correct, Judge. Whatever happens on my case is going to be dependent on what happens on Mr. Kilowald.
3 weeks.
To be May 20th.
So how about May 22nd? Zenda, what about May? You okay with that?
That works for me, Your Honor.
That's fine. Thanks, Judge.
Okay.
Joseph, I'll come down and see you, okay?
Yes, sir. Thank you. God bless you.
Take care, Joseph.
Okay.
For 37 and 38, People versus Curtis Smith Jr., 24254 FH, 24254 FH.
Ready, Judge?